We are. I'm going to start with our very first slide, which I like to call the wheel of estate planning. So this is really an overview of estate planning, and I like to think of it as a wheel because wheels have spokes, and estate planning is multiple spokes of the wheel. And we don't want to, in isolation, focus on one spoke because multiple spokes make up the wheel. And for us to approach estate planning in a holistic manner, we need to think of all of the different pieces. So that's what I'm going to try to go through and accomplish tonight. We're going to talk about the core basic documents that I think everyone should have. I want to go through if you should have a will plan as your main testamentary document versus a revocable trust plan, and how probate factors in and what that means for a decedent's estate, and when is probate indicated, depending on if you have a will versus a revocable trust. A very important spoke of the wheel of estate planning is understanding how you own property, how it's titled, how beneficiary designations factor in to the overall estate plan. And constantly, I want to emphasize how important it is to coordinate all of these so we don't make any unintended mistakes. Of course, when we're talking about estate planning, it's always good to go over taxes and where we currently are federally, Maryland, estate tax wise and gift tax wise, just so you can understand what the current climate is. I graduated from law school in 1998, so I've been doing this over 20 years, and I can't tell you how many times our estate planning taxes and exemptions have changed. It's just been a constant for the last 25 years. So it's just something that we'll touch on so you can see what the current climate is now. And then I'd like to wrap up by just highlighting charitable giving that you can incorporate into your planned giving, including your favorite charities, the Benedictine Foundation, and just making that part of the overall estate planning process. So one of the most basic documents out there is a financial power of attorney. And I like to call this a lifetime document because it's a document that you do while you're alive and it's operative while you're living, but it dies with you. So you expire, it expires, and your agent that you've designated can't use the financial power of attorney any longer. Now, this is an important document, I think, to put in place because it allows you to name an attorney in fact or your agent who can handle legal and financial matters on your behalf if you're not able to. Think you're disabled, incapacitated, had a stroke, or you're simply not available, i.e. you took a trip to the Bahamas and somebody back home needs to handle something on your behalf. In that situation, you're not disabled or incapacitated, but you are away and you're looking for someone to stand in your shoes. The most common type of power of attorney we see in our office is the durable power of attorney. And that is the document where when our clients sign it and they walk out the door, it is an effective document. They don't have to have a doctor declare them incapacitated or not able to function or handle their affairs. It is operative right then and there. So if your husband goes off to a fishing trip in Florida and he needs you to sign his name, you can do so through a durable power of attorney because it's effective from signing. And that is the most common power of attorney I see in our office. Versus the springing power of attorney, every now and then, a few people a year will insist on a power of attorney that they execute that will only be effective if two physicians declare them incapacitated, because they just do not feel comfortable having a document out there where someone can stand in their shoes for financial or legal matters. Now, with the financial power of attorney, my best advice is if you can get past that, fear of someone being your agent and being able to handle these matters, I prefer to see clients do a durable power of attorney that's effective at signing, and just pick people you implicitly trust and just realize those people are acting as a fiduciary for you, and they're going to act on your behalf and for your benefit as you would act if you were there to act. I think that's the most flexible approach. People use financial powers of attorney all the time. The most common thing is people talk about using a power of attorney for bill payment. If someone can't pay their bills, they'll start writing checks on behalf of the principal and sign their name. And they can do that through the power of attorney. But I see it also used if somebody was in the hospital, they have to go into a rehab center and they're not up for filling out paperwork, their power of attorney can do all of that for them. Or husband has a health insurance question, but he's never going to get on the phone with Care First. And so wife needs to handle all those kind of detailed things with their health insurance or with his long-term care insurance. The wife can use a power of attorney and be able to talk to the provider about whatever questions she may have related to, for example, her husband's health insurance. So they can be used in a lot of different manners and ways. I think they're just very important to have. Without it, basically, you would need to have a guardianship proceeding instituted. If, for example, somebody had all their assets just in their name, something happens to them, they can't execute a power of attorney, and people need to start getting in there and paying bills and stuff like that. Without the power of attorney, they would have to go through a guardianship proceeding, and that's not something that happens overnight. That takes time, and it takes money, and it could take months. So I just encourage people to look at having a power of attorney. The other thing I want to mention is we like to suggest people always name at least 2 folks to act as their agent. They could have it like, I name Bobby as my primary and I name Susie as my secondary. So it's like kind of cascading. If Bobby can't act, then Susie would step in. Or I've seen cases where wife wants to name her husband as the primary, but the husband isn't doing that great, but he's doing okay so that he could act, but really the daughters would probably be better. So maybe what they'll do is they'll name the 3 of them, the husband and the 2 daughters, as co-primaries. And then they can say they can act jointly, or they can act jointly or independently. So then you kind of have a panorama of people you trust, and the one that's there and able to act can do so. So it creates more flexibility. So whenever possible, I like to create flexibility in documents because you never know what type of situation is going to arise. The clients that come into our office, we have them sign our law firm's form financial power of attorney, but we also like them to sign Maryland's statutory power of attorney because we like to look at it as the Maryland form as a backup power of attorney, because sometimes we run into this a time or 2 a year. An institution will look at the date on a power of attorney and say, oh, this is too old, we're not going to accept it. And it's possible the principal doesn't have the ability to sign a new one. And you're kind of then fighting a battle. Well, it is a legitimate one, but they're saying it's too old. The Maryland power of attorney basically says, if it is the Maryland form and I haven't changed it and deleted it and put my provisions in it, if it really is the Maryland form, it gives the protection that basically if an institution refuses to accept it, then they have to pay attorney's fees to enforce it. So we like the benefit and the protection that includes. So we have our clients sign both. So that's a backup power of attorney, just in case somebody doesn't want to accept it. So the companion to the financial power of attorney, of course, is the healthcare power of attorney. And this form can also be captioned the medical advance directive. And the advance directive typically is made up of the document that's the power of attorney for healthcare that allows you to appoint healthcare agents. Then it also includes the living will declaration. Now, as you can imagine, the healthcare power of attorney allows you to appoint an agent, which again, we suggest a primary and a secondary agent be appointed, or again, you could do the co-agent situation, but you want to make sure you at least have 2 people named in case one of them can't act. But they're there to stand in and make healthcare decisions if you're not able to make your own healthcare decisions. Their purpose isn't to boss you around and tell you you need to choose this medical treatment when you've chosen a different medical treatment. That's not the function of this document. It's really, you can't advocate for yourself. So someone is there to do it on your behalf if you ever get to that point. And your healthcare agent is going to be the person that carries out your wishes as indicated on a living will. And a living will is basically a declaration of your desire for a natural death. So in the most typical form, it'll basically say, hey, if you're at an end stage or you're vegetative or terminal, and there's really nothing medically that can be done to bring you back, that you don't want to be kept on life support. You don't want to just be kept going for the sake of going. You're okay with medication just to alleviate pain and for comfort, but you're basically saying, hey, if there's no chance, I don't want to be continued to be hooked up to a machine. Now, if you're in that state, you can't advocate that position. So that's what your healthcare agent would do. So again, an advance directive, if anyone is ever asking you for your advance directive, that is your healthcare power of attorney and your living will. And depending on the law firm or the document you use, it could be one document captioned advance directive, or it could be two documents, the living will and the healthcare power of attorney. It doesn't matter what the format is. The importance is that you have a document that appoints your healthcare agent. And then if you do feel like you don't want to be kept on life support, if there's no chance, then you could go ahead and, put a living will in place. Every now and then people don't want a living will because they do want to be kept on life support. So you do want to understand what the document says and what your position is on that as it pertains to yourself. And occasionally people will say, well, I don't really want to be kept on life support, but I do want nutrition and hydration, or no food, but please make sure I'm hydrated, which is fine to do. It's a personal decision to everyone, just realizing that those things can still extend life. And, you just have to understand what your feelings are. And to the extent you can communicate that to your healthcare agents, that would go a long way when it comes time where they may have to make tough decisions. Okay. So the most form that's out there is Maryland's answer to a DNR. So Maryland had a do not resuscitate that they expanded into the most, I think like 10 years ago in 2013. And so when people say I need a DNR, the form you would use now is the most. And I like to hand this out to clients when they come in for meetings, so they know what the most form is. And so they also understand the most is completed for you on your behalf by a medical professional. So the most is done by a doctor, a nurse practitioner, or a PA. It's not signed by me. It's not signed by you. But I like people to have familiarity with it because it is the form that gets into the do not resuscitate, which is different than the living will, which is not about resuscitation. The living will is about your end stage and you want to die naturally. Okay. So if you want to supplement, not overrule the living will and healthcare power, a lot of people like this most form. If an individual has a disability and they're not able to do the most form on their behalf, their healthcare agent can meet with the physician, or their guardian can meet with the physician and do the most on their behalf. And the most form is not just do not resuscitate. It has other medical orders, like about artificial ventilation, fluid nutrition. It has, kidney dialysis, blood transfusion. It covers a lot of different areas that the doctor would go over with you. So I like to look at this as a supplemental form that's more detailed about an individual's healthcare decisions. It does not replace the healthcare power of attorney because there's no place on the most to appoint an agent. So just again, keep in mind this form is put in front of like your primary care doctor or a PA or nurse practitioner. Okay. So then now we go into kind of like the cornerstone document, the last will and testament. Everyone has familiarity with the will and what it is. And I like to stress that the will can only govern and distribute assets flowing through the will. And we're going to unpack that more as we go on. But there is a common misconception where people might call me up and say, I need a will. And they think by doing a will, they are doing the whole wheel of estate planning. And again, I like to go back to my wheel analogy. The will is just one spoke of the wheel. And by only focusing on the will, you're probably missing other pieces of your estate planning. But anyway, nonetheless, the will is important to have because it's the testamentary document that comes into being when you pass away. Somebody can do 15 wills during their lifetime, which is fine. Each subsequent will revokes a prior will. And it's basically the last will you did is the one that is going to be the controlling will instrument. Obviously, some of the main things a will does is appoint the personal representative, which is like the executor. Personal representative is the name Maryland uses for somebody who would administer your estate. If one has minor children, that's where you would state who you would like to be the guardians if both parents are gone. The will can do crafty tax planning if that is important. The will can also create trusts for a variety of scenarios. There can be individuals living with disabilities and autism, things like that nature, who need a trust. The will can establish a trust for those individuals that can continue for their lifetime. It can establish a trust for your spouse, if your spouse perhaps needs a trust for whatever reason, or small children or young adult beneficiaries or people who are not good at handling money. The will can create those trusts for those individuals based on whatever your current situation or need is. Now, fast forward from the will to a revocable trust. And I like to call the revocable trust like the will substitute. So when clients come into our office and say, I want to do a will, I do always like to explain you have a choice in vehicle. You can do a will as your main document, or you can do a revocable living trust. And don't necessarily be scared by the name trust, because the revocable trust, like I said, it's kind of like a will substitute. It's a document that is going to dispose of your assets when you pass away, in part, just like the will does. The interesting thing, though, is the trust is a living creation once you execute it, whereas the will doesn't come into being. You sign your will, but then it doesn't really spring into life until you pass away. The trust, on the other hand, if you go in and establish it, you're generally called the grantor, the settlor. That's the lingo that you'll see in there. And then typically you'll name yourself as the trustee. And while you're alive, you're the beneficiary. So generally you're all three parties at first when you create the living trust. The revocable living trust, though, does require that you still put together a will, but it's a different kind of will. It's called a pour over will. It's just a will that makes sure the assets you didn't put in your trust prior to dying pass to the trust, because the trust is the governing document. Now, like the will, the revocable trust can incorporate the same exact estate tax planning, subtrusts for beneficiaries, determine the method in which assets are disposed of, who gets trusts, things like that. Neither one of them are superior as far as what type of disposition you create in your will or your revocable trust. So they're alike, in that regard. And I want to mention one of the type of subtrusts one can create under their will or revocable trust, often called a special needs trust. And that's generally set up. It can be done during lifetime. If someone is living with special needs and they're a beneficiary, that is, they're someone that's part of your life and you want to provide for them, you could do so through your will or revocable trust. Now, I have a number of cases where people will come in and they'll say, my granddaughter has autism and it's a serious case and they're on government aid and they will continue to be receiving government benefits the rest of their life. And I want to provide for them. And in one case, like a grandmother wanted to provide for a grandchild, and the grandchild's parents had already established their own special needs trust for their child. So then what the grandmother did in her will, whatever she provided for the granddaughter, she directed it to the trust, the special needs trust already created. And so we had to make sure we got the exact title and name of that trust, because we wanted to direct it to this special needs trust created in Mississippi for the granddaughter by her parents. So that is certainly fine. Your will or your trust can direct assets into a special needs trust that's already been created by a third party, and it's an existing trust. Or we'll have cases where no one's created a lifetime trust. The trust is going to be created under the will or the revocable trust. And obviously the reason they're doing that for the individual that's living with the special needs is that they don't want their inheritance to cause them to lose the eligibility for benefits. And so just to give that child living with special needs an outright inheritance is kind of counterproductive. So why not have it pass into a special needs trust that your will or your revocable trust can create, and it's there to protect them so that they can be eligible for the benefits they're used to receiving, but then they can receive distributions from the trust for their needs that go beyond what the government benefits provide. And then upon that person's passing, then, if they had kids, it could go to their kids. If they had siblings, it could then pass to their siblings, or you could have whatever alternative disposition, but your will and your revocable trust can create all that. And it is, it's very common to see people who have a family member where there's an individual living with developmental disabilities, autism, and things like that. And they want to provide, but they don't want them to lose their eligibility. So it's not hard to have your attorney draft within the will or revocable trust this subtrust that's a special needs trust. So I like to compare a will plan with a revocable trust plan when clients come into our office. And there's a lot of information on this slide, which you can review at your leisure, but I like to help people understand what the difference is. We are not a state like California where probate is so expensive, time consuming, protracted, and just something to avoid at all costs, that anyone that does an estate plan in California does a revocable trust. I feel like in Maryland, you really have a legitimate choice. If you do a will, generally that's going to cause there to be probate that occurs for any assets just in your name. And I'm going to flesh that out a little bit more. Wills are simpler from the standpoint, you come in, we do a will, you walk out the door, you don't have to worry about retitling your assets in a trust. You're just kind of out there waiting for your will to come into effect because you pass away. Then when you pass away, then the Register of Wills and the Orphans Court get involved in the administration of the estate because they're like an oversight body. There are probate fees that are applied to your probate assets that the will distributes. And again, I'll give you examples of these in a minute. When you have a will and there's probate, there's a minimum 6 months. Things have to be open because of the creditor period. That does not mean that all activity freezes. People sell houses during that period of time. So I don't want people to think probate means you're sitting there frozen and can't do anything with the decedent's assets. That's not the case. But a lot of times, depending on the type of probate estate, you may have to hire a law firm to assist with it, and that costs money and fees. Plus there's a probate fee that's payable. On the other hand, folks that really want to avoid probate for whatever reason, they may have heard that it's bad. They may have heard that it gets tied up and you pay huge fees, or they like the fact that a revocable trust isn't public, so that your trust and what it says doesn't get filed with the Register of Wills. So the public at large, after you pass, can't go read and see what your trust says like they can with a will, which is made available to the public if you order someone's will. Revocable trust costs more money to create. They just simply do because there's more documentation involved. And then there's the aspect of retitling the assets in your trust that are appropriate for being retitled in the trust so as to avoid probate. So neither the will or the trust is superior as far as estate tax savings or income tax savings. Neither one of them offer an advantage in that regard. So you can't say, hey, I'm going to do a revocable trust because I'm going to save all these estate taxes. That just isn't the case at all. So anyway, so you have a choice whether you want to do a will plan or revocable trust plan. So I want to just explain when probate comes into being. You have to open a probate estate if there's probate property. So you need to understand what's probate property, and that's when you die having an asset in your name. That means if you own everything with your spouse jointly with rights of survivorship, and one of you dies, there is not probate because it goes to the survivor automatically as survivorship. But when the second person dies, those assets are just in their name and there would be probate in that particular case. Sometimes, let's say you have 3 children and their parent dies and the parents leave a farm to the 3 kids. The 3 kids will take title as tenants in common. A tenants in common 1/3 interest in any type of property, whether it's real or personal property, is a probate asset when that person dies because their interest flows through their estate, flows through their will, versus if they took title as tenants, like joint tenants with rights of survivorship, that doesn't go through your will. That goes to the last guy standing, basically. So there is a difference. So if you ever inherited a piece of property, real property, from your parents and there's multiple siblings, rest assured you have a tenant in common interest. And that will go through your will, not through your surviving siblings or surviving joint tenants. So again, probate property would be as if you have a business in your name, you have a checking account in your name, bank account, stocks, investment account, stuff that's just in your name alone that isn't jointly owned and doesn't have a beneficiary designation tied to it. That's going to cause there to be a probate estate. And probate is a process that we go through with the Register of Wills in the county where the decedent resided at the time of death. So you would utilize the county in Maryland, that Register of Wills, in order to open up the probate estate. And basically there's a battery of paperwork that is submitted and signed by the appointed personal representative. And then that goes to the Register of Wills. And then if there aren't any issues, they will appoint the named personal representative and issue letters of administration, which is a document with a seal. And that's what the personal representative, which we call the PR, presents to anyone that it has to deal with, banks, brokerage firms, selling property, title companies. They present that document, the letters of administration, and that tells the world they are the PR. They don't go handing out copies of the decedent's will. A bank doesn't need to see the decedent's will. All they need is the letter of administration because the Register of Wills is already certified that the will is valid. And then they issue that government document to appoint the personal representative. And then probate is a process where basically you have a governing body, the Register of Wills and the Orphans Court, overseeing the process so that the assets are distributed in accordance with the will. So when probate isn't involved, because there's no reason, there's no asset in the decedent's name and there's no probate property, then you don't have the Register of Wills involvement. Or if you made sure everything was titled in the trust, the trustee is going to be the one that manages the assets and distributes them. There's no one looking over their shoulder. So you can look at that as a good thing or bad thing, depending on, do you like the idea of your estate being administered where there's an agency making sure the PR is doing what they're supposed to do? So we see a little bit of everything, to be honest. We see some people die and have no probate estate, and then we see other people die and have large probate estates. Rest assured, to the extent you have probate assets in your name, there are fees payable to the Register of Wills. And so if you just look at this, like if if a decedent's estate was $500,000 to $1 million, then at the end of the administration, there's a check cut to the Register of Wills for $1,000. Now scroll down here to a pretty large estate in Maryland. If this estate was between 7.5 million and 10 million, you would have to pay a fee to the register of $10,000, which is a lot of money. But I like to compare that in California. The probate fee for a $7.5 million estate would be $75,000. If it was a $10 million estate, the probate fee would be $100,000 in California. So probate is less expensive than here in Maryland than in California or other states. So just understand that these fees exist. Whereas if you went with a revocable trust plan, there are no fees that are paid if there are no probate assets. So by setting up a revocable trust, you're avoiding probate fees on the back end. Okay. So a spoke in the wheel is understanding ownership and titling. It is great to do your foundational estate planning documents, but if you don't understand the title of property, you may risk not understanding how your assets actually pass. Again, if I only own property in my name, or I own tenants in common with my brothers and sister, those assets are disposed of through my will. But if I have another asset that I own jointly with rights of survivorship, or with a husband, for example, that would be tenants by the entirety, it doesn't matter what I put in my will. The ownership per the deed controls how that asset passes. So if I die, the interest passes to the surviving owner. It does not matter that my will said my interest goes to such and such charity. It passes by operation of law. So it's important to understand how property is titled and whether your will can control the disposition of it. Again, a husband and wife have property, tenants by the entirety. That's going to pass survivorship at the first death. But then when the survivor owns all of it, the survivor's will controls. To that end, if a husband and wife have everything joint, but then they have totally different will dispositions at the second death, that is a uncoordinated estate plan, because you can't predict who's going to die last, and it would be the survivor's will that controls. So if their wills have totally different secondary beneficiaries, then it's just kind of the assets are going to pass as one of them has provided, not as both. So I like to encourage husband and wives thinking in terms of having a unified estate plan, especially in the case of having jointly titled assets. Payable on death and transfer on death are designations that can be used to pass assets directly to a named beneficiary. And you can put these on bank accounts or brokerage accounts. And a life estate is, I'll sometimes have people who want to do a life estate deed where they have property and they want to retain lifetime rights to it, but then they want the deed to say upon my death, it passes to my kids. A life estate deed does avoid probate because it doesn't flow through the will when the life tenant dies. It flows out to the named, we call them remainder men, but out to the kids. So that is a method of avoiding probate. Now, POD stands for payable on death and is used with bank accounts and CDs. So you could roll into your bank and say, I have a bank account and I want a POD form. And I want to name, you could say, I want to name my trust the POD beneficiary, or I want to name my daughter the POD beneficiary. And basically what happens is upon your death, that CD or that bank account will pass automatically. They just have to go in with the death certificate and their ID, and that account would go to them and avoid probate. You could also do that. TOD stands for transfer on death, and that's used with like a brokerage, like investment account, bond account, mutual fund account. That's where you would have them do a TOD. Now, you have to be careful with these and not use them without thinking holistically about the entire estate plan. I once had someone who had a will that had a very nice, nifty special needs trust set up for a daughter who was living with special needs, received government aid. Then separately, she had large CDs and bank accounts over at the bank, which her POD designation should have said is directed to the special needs trust under my will. Instead of doing that independently, the decedent during her lifetime just named the daughter living with special needs as the direct beneficiary. And so what happened when she died, the bank had no choice but to pay it directly to the daughter. They did not care that the decedent's will provided a fancy special needs trust because they were contractually bound to direct it to the named person, and it wasn't the special needs trust. So that's a goof. That is where the spokes of the wheel aren't lining up and the estate plan isn't coordinated. So you don't want to use these in a manner that it unseats what your overall estate planning goals are. It also doesn't have the fancy alternative instructions in case you have a POD beneficiary and they die. Like if somebody said, I want this to go to my daughter, but if my daughter isn't living, then I want half to go to her husband and the other half to go to her 3 kids. You can do all that alternative language, contingent. You can get as creative as you want in a will or revocable trust. You can write it up however you want. These POD, TOD forms are very basic. They may not even let you do a contingent beneficiary. So they have their limitations. They do help an asset that would otherwise avoid probate. An asset, that otherwise would go through probate, they can be used to avoid probate. So not subject to the probate fee and not go through the will, which may meet a goal of someone's. But if you're leaving it to a minor, that's a bad use of that POD because it should be passing to a minor through a trust under somebody's will until they're of a certain age. So you just have to be careful and consider the whole estate planning wheel when you do go to complete these, if you ever do. Beneficiary designations are something we see attached to like life insurance policies. If you ever have a life insurance policy that you take it out with your agent or you have it through work, you'll receive the beneficiary designation form and you'll need to complete a primary. Very important, complete a secondary beneficiary. I see this all the time where people name a primary and they forget to name the secondary. But ultimately, if you name your spouse, one of you is going to go first. So you should think about making sure your secondary beneficiaries are up to date. Again, this is another thing where your life insurance policy shouldn't go to your beneficiary who's living with special needs. If there's a special needs trust out there, make sure the beneficiary references that and not that person's name alone. Okay. We also do beneficiary designations when we have IRAs, like retirement plans or 401k plans at work. When you go to work, they'll give you their beneficiary designation forms. You fill that out at the beginning, and a lot of times you forget about them. Again, you can name individuals, but if somebody should have a trust under a will or a revocable trust, you need to make sure the language says the IRA goes to that trust, for example. When things happen, get divorced, somebody passes away, you should review your beneficiary designations. So it's very important. Another thing I like to tell people to look for is like they might name their spouse as the primary beneficiary and then their kids equally as the secondary. But let's say they have 4 kids and one kid dies. What happens if the spouse is no longer? Does that, let's just say it's $1 million IRA. Does it go to the 3 living kids? Or does it go 4 ways into the children of a deceased beneficiary? How do you know? Well, you look at that beneficiary designation. If it has a per stirpes, which is a Latin word that means of the root, if it has a per stirpes option and that's checked, then it will go to a deceased beneficiary's descendants and not to all to the other surviving beneficiaries. But those are little details you need to keep in mind when you complete your beneficiary designations and just thinking about how you want things to pass. Again, a beneficiary designation is a contract that the institution has to honor irrespective of what your will says. So your beneficiary designation and the POD, TOD almost act like mini wills because they dispose of that asset. So that's why when people say, I need a will, and they think they're covering everything, they're forgetting about all the assets that may pass by beneficiary designation and how important it is to make sure those are up to date and appropriately reflect what your estate planning intentions are. So just a quick note on some common estate planning mistakes. I've said this a couple times. It's the mindset that I need a will or I need a trust, and that just doing that is going to make sure all your affairs are in order. That really isn't the case. We want to take a holistic approach, understand our assets, understand how do they pass. Do they pass through the will? Do they pass by survivorship? Because that's how it's written in the deed. So you have to pull the deed and actually look at it. Do they pass by a beneficiary designation? Did you put a POD designation? So you need to understand what you're dealing with and what document's going to control its disposition. And, you know, I do, like in the example where the mom named her daughter who lived with special needs as a direct beneficiary, she didn't line up her property ownership and her designations with the plan where she created a nice special needs trust through a will. So another thing is just like putting things on a shelf and not regularly reviewing them, such as, you know, not looking at your beneficiary designations because maybe somebody passed away. Or I know in Maryland, if you have a life insurance policy and you name your spouse and then they divorce, the spouse is still stands to take a life insurance policy in Maryland, an ex-spouse. So unlike where the spouse is treated as predeceasing in the Maryland will, so any interest in a will is revoked, their interest as a beneficiary of a life insurance policy under current Maryland law, they would still take if you did not update that beneficiary designation. And that is a state by state issue. So anyway, just, you know, some things to keep in mind, food for thought. So I'm going to go over estate taxes and where we are at now. When I first started this, the exemption was around $600,000. So if you had $1 million in assets, then your estate was going to pay 55% estate tax on anything above our $600,000 exemption. Well, in 25 years, we've come a long way. Our state tax rate is still high. It's 40%, but it's 15% less than what we started with when I began. And now instead of the exemption being $600,000 a person, it's $12,920,000. That's almost $26 million for a couple. So if you're under that, your kids don't have to worry about a federal estate tax. Now, that exemption is increasing next year, 24, increasing again in 25 because it's inflation indexed. But then in 2026 is sunsetting, because that's what the law that was passed in 2017 said. Our increased exemptions are going to go back to 5 million, but indexed for inflation. So they'll probably be 6.5 or 7 million per person in 2026. For a lot of people, they're still going to be way under that. And so there wouldn't be any estate tax exemption. For over 10 years, at least, we've had the ability of a first spouse to die's exemption. Again, right now, 12,920,000, being able to be grabbed and added to the surviving spouse. So we call that portability of exemption. Something you should be aware of if you're in a taxable situation, you can pass assets to a charity or your spouse that's a U.S. citizen, and it would qualify for an unlimited deduction regardless of the size of your estate. So usually if there's a wealthy couple, when the first spouse dies, usually there's not estate tax because their estate plan takes advantage of the unlimited marital deduction. Now, something that's important to understand is when you die owning an asset, like you die owning a farm that, you know, maybe somebody purchased a farm back in the 50s for 50 grand. And today, when they die, it's worth 2 million. If they sold that farm during their lifetime, the capital gains would be outrageous because they'd get 2 million, but they only paid 50 for it. So they have enormous capital gains of 1,950,000. When you die owning an asset, you are passing along to your heirs a new basis. So they would get a $2 million basis in that farm. So if they turn around and sold it, there would be zero capital gains. So that's a very important thing to understand about assets that are in your estate. When you pass away, they get a new basis when you die. Versus if you gave that farm to little Johnny, he would get your $50,000 basis. But if you made Johnny wait until you died, then it would wash through your estate and he would get a $2 million basis. So something to think about. It's actually an income tax issue as it relates to estates and assets flowing through one's estate. Maryland estate tax rate is 16%, and Maryland has a $5 million estate tax exemption. So it's a lower exemption. A couple each have 5 million, so together they have 10 million. Just like the feds allow the exemption to be ported and transferred to the surviving spouse, you can do the same thing in Maryland. So that's just a nice feature to have. Maryland does have a special exclusion for ag property, where if you're going to have, if your heirs are going to keep your property as farmland for 10 years or as farm property like combine, they don't sell it for 10 years, the that decedent's estate can exclude up to $5 million worth of farm property, again, whether it's personal property or ag. Otherwise, if they're even over that, there's a 5% tax rate. So it's obviously lower. So they're definitely trying to help the farming industry, just so that they don't have to sell the farm in order to pay estate taxes. That has been Maryland's attempt to help with that issue. That, you know, in the 90s, 80s, family farms had to be sold because they couldn't handle the estate taxes and there weren't other liquid assets. Maryland does have an inheritance tax. It is one of the very few estates that actually has an estate tax and an inheritance tax, but the inheritance tax is not based on whether your assets are over 5 million. The inheritance tax simply looks at who is inheriting and are they exempt from the tax. So your core nuclear family is going to be exempt. Your ancestors, parents, spouse, children, lineal descendants, grandkids, siblings, they're all exempt. But if you start leaving your assets to a girlfriend, boyfriend, nieces, nephews, friends, your gardener, your good girlfriend, good boyfriend, whatever that is, they're not exempt. And if they receive more than $1,000, then they are going to be subject to a 10% inheritance tax. And your will can decide if your estate covers that or if you make them pay the inheritance tax on what they receive. And that's something we talk about when we recognize that situation in our estates. So inheritance tax is an issue, and it simply applies to a Maryland resident's estate when the person inheriting doesn't fall into the exempt class. Okay. The only asset that you can get around that with is life insurance. If your nephew is named as a beneficiary of a life insurance policy, there's no inheritance tax because life insurance is special. But otherwise, anything else they receive would be subject to the 10%. And of course, charities are exempt. So you could leave an unlimited amount to charitable organization like the Benedictine Foundation, and there would not be an inheritance tax assessed. Just want you to know there is a federal gift tax. Maryland does not have a gift tax. So if somebody had a taxable estate and needed to give a lot of assets away, their federal exemption, $12,920,000, gets reduced by gifts you made. So if you made a $3 million gift and you die, your exemption is now $9,920,000. Versus in Maryland, the exemption doesn't get reduced. It's still $5 million when you die because Maryland doesn't have a gift tax. I mentioned this before, but if you give your son or daughter that piece of property, they get your basis in it. They don't get a new higher basis. So that's an issue if you think they might sell it because they might have an income tax, capital gain income tax down the road if they sell it and don't die with it. Just like when you die, there's an unlimited charitable deduction and unlimited marital deduction. The same is true when you make gifts to charity. There's no tax consequence, or if you transfer assets back and forth between your spouse, it's an unlimited marital deduction. Okay. So I do want to close this by talking about like benefiting your charities as part of your overall estate plan. Many of us have charities that are near and dear to our hearts. The Benedictine Foundation may be a charity that you support during your lifetime, and you want to continue supporting after you're gone. Now, if somebody has an IRA and they are 70 and a half or older, they can have distributions from the IRA, which are otherwise ordinary income. So taxed at your ordinary income tax rate. They can have an IRA transfer up to $100,000 to a charity like the Benedictine Foundation. And it's great because that doesn't then create taxable income for them. They do not get a charitable income tax deduction, but they also don't ratchet up their income, which can cause there to be problems with certain deductions that get phased out when your AGI gets high. So this qualified charitable distribution, which we talk about as we refer to as QCDs, is when someone transfers something from their IRA to a charity. They have to be 70 and a half. You may know now that once you reach 73, you have to start required minimum distributions, which means you're forced, based on your life expectancy, to take down your IRA. You have to take a certain amount or they're going to tax you. They're going to assess a 50% excise tax. So a lot of people who are charitably inclined, who are in the required minimum distribution mode and don't need or want the income, they use their IRA to fund their church, the Benedictine Foundation, or other charitable interests in order to minimize taxable income for themselves. And they're still benefiting the charities that they want to benefit. So the limit right now is 100,000. It's going up starting next year. So it's going to be indexed for inflation. So it'll be higher than 100,000. But anyway, this is permanent law now. For many years, it was not permanent law. We'd have it for 1 year and then we'd be waiting towards the end of the year to see if they'd extend it. But now it is permanent law. It's just a great way if you have an IRA and you're of that age, 70 and a half or older, and you would like to benefit the Benedictine Foundation or charity. And sticking with the IRA, one of my favorite ways for people to provide charitable bequests, so to speak, in their estate planning when they pass away is to use their IRA or to use their retirement plan. Because the retirement plans, if you're leaving them to your kids pay tax on every dollar that comes out. So if your kids are higher income earners and they receive an IRA worth $500,000, pretty much half of that IRA is gone in taxes that they have to take down within 10 years. Why not name the Benedictine Foundation or your favorite charity as a beneficiary of that IRA? They could be a percentage, you could name them 25%, or they could receive all of it. Or you might have somebody name their primary beneficiary, the special needs trust that they've established. And then if that individual living with special needs didn't survive them, the secondary beneficiary could be the Benedictine Foundation. But charities don't pay tax on the retirement plans when they receive it, whereas your kids do if they receive an IRA. So I know a lot of times people are like, oh, I want to update my will and put $50,000 in there for the Benedictine Foundation. And that does qualify as a charitable estate tax deduction. That is good planning, but you've just taken $50,000 of good non-taxable assets and given it to a charity who's not going to pay taxes anyway. So I like to ask those individuals, wait a minute, do you have retirement plans? Why don't you try to get, if you have charitable aspirations, why don't you try to get that over to the charity to whatever degree you want to benefit them, and save the assets that don't have an income tax liability for your kids or other beneficiaries that aren't charities. It's super easy to include a charity as a beneficiary of your IRA. You just call up your custodian, or I mean, you could do it with life insurance policy too, but with an IRA, you call up the custodian, ask for the beneficiary designation form, and then just choose the percentage. You don't even have to see your attorney. per se in order to do that. Obviously, if your will says I want $50,000 to go to Benedictine Foundation, and then you say, hey, I want to use my IRA, and you update your IRA, but then don't remove the $50,000 request from the will, the Benedictine Foundation will inherit both places, which is great for them. But is that what you intended? And that goes back to the idea of coordinating all of your pieces. So if you only want them to inherit through the beneficiary designation, then you need to remove them from the will if you don't want them inheriting both places. Okay. Not everyone has a nice big IRA. So some, there are other ways, obviously, to make planned gifts to the Benedictine Foundation or to your other charities. Obviously, some of these are their own seminar, but charitable remainder trusts, lead trusts, and charitable gift annuities. As you can see, all of those vehicles have charitable at the front. They're designed to benefit non-charities, such as yourself or family members, but then also like a charitable remainder trust. You could establish one under your will or revocable trust for your kids for their lifetime. And then say upon that child's death, what's left goes to the Benedictine Foundation. So they benefit as a back-end beneficiary. It might be some years, but they ultimately are a beneficiary. Or charitable lead trusts are where the charity is the beneficiary at the beginning. And then once their years of benefiting ends, then it goes to the family. So it's like just the reverse. Usually charitable lead trusts, like you'll hear like Jacqueline Kennedy Onassis created a charitable lead trust. It's typically done with pretty wealthy estates. Is generally where you see those more because there's an estate planning wealth transfer component that they're incorporating with their charitable planning. Charitable gift annuities are something that charities offer, where you could go and say, hey, charity, I want to give you $100,000. I want to retain an annuity that's based on my life expectancy. And there's a chart that says, based on your age, you might get 8% for your lifetime. And then upon your death, it goes to the Benedictine Foundation if you set it up with them. Those are like easy to use because you don't have to hire an attorney like you do for the remainder trust or the lead trust. But usually you work with the charity to set these up, and you get an income stream and you get an income tax deduction. And then when you're gone, you're no longer there to make annual gifts to the charity, but your annuity transfers over to them. Of course, you can write your charity into your will or foundation as well. So anyway, there's, a number of ways that you can benefit the Benedictine Foundation or other charities by incorporating it into your planning. And you can go as sophisticated or as basic as you like. So that really concludes this section of this, broadcast on estate planning and the wheel of estate planning and all the spokes of the wheel. And just, again, the goal is to make sure that you do holistic and coordinated estate planning. So we have time for question and answer. So if anyone would like to ask questions, you can type in. I see that there's already a question typed in, so I'll just read this question. And it looks like there's only one question so far. So you're welcome to type it in through the chat feature, or if you want to go live and ask the question, that's fine. But the question is how do we decide how much money should go into a special needs trust? Whew. You know how they say every child is unique and every child is different? This question is obviously based on someone's very specific situation. I have seen where someone has 3 kids and their estate is divided 3 ways, and the child living with special needs has a special needs trust that they establish, and 1/3 goes into it. And they're just basing it on 3 kids, and we want it to go 3 ways. Somebody might take a different approach and say, in this situation, our child living with special needs doesn't have the same opportunities as our other 2 kids. Therefore, we may need to help that individual out further. it can be based on age. Are you funding a special needs trust for someone that's 15 or are they 65? Like, have you projected what their needs might be in conjunction with what the governmental benefits are? So you also have to remember that if that person, is your goal to help them and supplement them? And do you see the trust running out during their lifetime, or is your goal to make sure that it's well, funded so that they die without having every supplemental need met that they needed to have met, and you're expecting it then to go to your remaining heirs. So it is really difficult to say broadly, do you put 50,000 or 500,000, because it's just going to be based on your particular situation. So let's see. Let me just go up. And then, so there's one response. I don't know if everyone's reading the chat or not, but Kata Smith wrote, I work with an agency who assists individuals with special needs. Actually, that sounds like this is a question. What would be the best route to take to ensure that their final expenses are taken care of as well as their assets? So I'm a big fan of establishing special needs trusts for those individuals. Now, if they have assets, it kind of goes back to, I don't know if they're capable of doing a will, but do they have the type of assets where they can create a first party special needs trust that has the provision where the person living with the disability sets up the trust or their guardian sets it up, but then it has a disposition? Or do they have the types of assets like in a bank account where a POD beneficiary can be put on there and it can be left to their parents or their siblings? So it is important to understand if an individual passes away, doesn't have beneficiary designations or POD designations, and doesn't have a will, the state law determines how assets are inherited, and it's really to your next of kin. So a person living with special needs dies and they have two parents, their assets go to their parents. Again, if it wasn't already owned jointly with someone or didn't have like a beneficiary designation on it. So, so the state law will kick in. If parents aren't living, then next of kin would be siblings. There are no siblings, then descendants of siblings, so nieces and nephews. There's a question, can an agency be a power of attorney for financials, or is it a specific person? Generally, it's a specific person, but I have seen where, like, sometimes, occasionally, not a lot, like they may name an attorney in a law firm or an accountant, or they might say if the attorney named or the accountant named can't act, that accounting firm can appoint someone. So on a more simplistic level, I have seen where a person's like local accounting firm or law firm would have somebody within it. But I'm sure, organizations like PNC, US Trust, Y Financial here in Easton, they may agree to serve as a power of attorney for somebody, whereas they agree to serve as a personal representative of an estate or trustee of a trust. They may also do that. So it is definitely possible if somebody doesn't really have that trusted person. Another question, can a POD designation be the agency that takes care of them, or is there representative payee? And a POD designation, you can name, when I talk about a payable and death designation, I'm basically talking about you go into Bank of America and ask for their POD form, and you can name your brother Bill, you can name your spouse, your children, or you can name a trust you established. You could name a charity if you wanted. There's no reason you can't name an institution or an agency as well. There's no reason. the representative payee, I think that's having to do with like Social Security payments and who is the representative payee. Again, you can really name whoever you want on a POD designation, and it can be an entity. But I tend to see it. I tend to see people name their revocable trust under their will, or just individuals is what is most common. So this question is, what is the example when you would recommend utilizing an ABLES account in lieu of a special needs trust? You know, that is, I don't know how long that's been around in Maryland. I am definitely not an expert on it, but I do know that it's there for people living with special needs who I think develop those disabilities like before age 26. So obviously you have to qualify. But I don't look at those as an either or. Remember how we talked about, like, you could have healthcare power of attorney, living will, and also do the most, that they all work together for somebody's or not their medical, you know, wishes and needs. I don't think that the Maryland ABLE account would be used exclusive to the special needs trust. I think you can use both because they serve different functions. The ABLE account is going to give that person living with special needs the ability to access funds, use funds that don't disqualify them from aid. So that serves a niche that the special needs trust is designed to cover supplemental needs that government benefits don't cover. So I think they can complement each other and you can set them up. But I am, you know, I'm not an encyclopedia on ABLES. If I was ever to really dive into that, I would get on the website. They have a really nice like FAQ section, but I think you can do both, and it is appropriate in a number of cases. I think ABLES is probably a little easier because the special needs trust, obviously meeting an attorney, there's an expense involved, but an ABLES do on your own. But eventually, for those that have individuals living with autism and disabilities, your estate plan should, in theory, incorporate some type of special needs trust also, because you're talking about your assets passing on to those individuals in a trust manner that's not going to disqualify them from aid. So I think that's the end of my questions that I see on the chat. So Claudia, do you have any questions or comments? Or
no, I think you've answered all of the questions. Thank you so much for providing all this information.
Oh, you're welcome.
I hope it's been helpful for everybody. We will email out the recording to everybody so that you have it and can refer to it. JoRhea has also offered to share her slides, so we'll email those out to everybody as well. And if you have any questions on Benedictine Foundation, and please feel free to reach out to JoRhea if you're interested in some estate planning advice. Please let us know also if this was helpful. And we try to do at least one of these once a year so that we can provide some information for our folks and anybody who wants to join us. So thank you all for coming.
Okay. Bye.
Bye, everybody.
Bye.